can't hear you, Judge. I can't hear you.
He can't hear you? Well, Mr. Birnbaum, if you want to move up closer, let's see if that works. And if it doesn't work, I'll go back there. I'll move away.
Yeah.
I don't want anybody
That would be good.
But why don't you move up here to the council table?
I'm really here just as a spectator today.
I beg your pardon?
I'm just here as a spectator. I just couldn't hear.
Well, you filed a motion, Mr. Birnbaum. I've known you, we've been involved, you and I, and with balls for years now, so I know who you are. And your motion, apparently this is your, one of these motions is yours. You want the court to do something?
Yes, let me give you something. Yeah, let me give you something to the bailiff here. If you would have him get it.
I assume that yes, sir. Do you already have a copy of it?
Yeah, I have a copy.
Okay. Mr. Fleming, I don't know if you have, but I don't look at anything that both sides doesn't know that I've looked at.
Yes, sir, I've seen that before.
Well, Mr. Birnbaum, are you telling me, sir, that you want to be a spectator, you do not want to participate? This is your lawsuit.
Did you take a look at this? I'm getting a little absent-minded too. So, I may have handed you the wrong one. Bailiff, can you hand that back to me and make sure I passed him the right one, because I have several versions of this. Let me, if you just hold it for just a minute.
Well, it's the pumpkin one.
Yeah, that's, okay. I just want to make sure, I sometimes do silly things.
I'm sorry.
Sometimes I'm getting up in age, sometimes I do silly things, and I want to, I don't do anything on the spur of the moment anymore, and so if I do something, I sort of reserve the right to take it back. I'm 78 years old.
You want to withdraw that?
No. I just want to make sure that I handed you the right one. I sometimes, when we get up in age, we do things.
The agenda today is that I'll ask the clerk to, it's got a file mark on it, so, okay. I guess it's already a record.
Yeah, it's already filed. Judge, could you show me your assignment? Would you have the bailiff show me your assignment? And after we looked at this, then we can decide who's going to come, whether you're going to come here or I'm going to come up there.
It's better for you to come up here for me.
You can come up here.
Because now I've got all my equipment, right?
If I can hear him from here, then you can hear me from here too.
Just speak up.
Thank you. And I have a tendency sometimes to go into a rattle mode, so if I do, please ask me to repeat. There's a big pause in here. I've noted that on the recordings that we have, or the transcripts, the pauses don't show up. So I may at some times interject a pause or a long pause, and also the voice levels don't show up, so I may say voice level 3 like I'm saying right now. Okay, on 3. Judge, I object to proceedings, voice level 4. Judge, I object to proceedings before you've shown me your assignment. Unvoice level 3. Just for the record, that was Mr. Fleming going up to the judge before my comment to see the assignment.
You know where
Long pause here. It is now 10:10.
pretty close to that, Mr. Birnbaum.
Thank you, Judge. I can hear you.
Mr. Fleming, I notice you've got one that's got a seal on it, so we might need to trade in that one over and give it to the clerk. You may have an original instead of a copy.
He does.
Well, that's the second sheet there. Well, no, that's what, let Mr. Birnbaum.
Judge, I can't hear you.
I was just asking the bailiff, well, why don't you move up close?
Just move up here.
He can come up here. I can hear him. I'd like to see the assignment.
You're looking at it.
Thank you, Judge, for coming up here.
I beg your pardon?
Thank you for coming by here.
Coming by where?
Here, can you see me? Oh, you're just passing by.
No, sir, you say you're hard of hearing. I've asked you to move from the front pew up here to the council table, and I'll sit at the council table so you and I can hear each other. I don't want you to miss a single thing, Mr. Birnbaum.
Judge, this is just a piece of paper just like the one that I've got.
Okay?
And we can talk about this one right here.
Fine. Mr. Birnbaum, you ready to proceed on your motion to cancel out the last order entered by the court?
No, sir.
All right, the motion's denied.
No. The reason is you have not shown me your assignment. That is not valid. That's just a fucking piece of paper.
I understand that you think a piece of paper is not a valid one. Thank you.
Judge,
Don't talk.
Judge, don't talk to me here. I have a First Amendment right on this, Judge. Now, if you want me to stop this, have you ever seen a piece of paper that looked like that one? Judge Mary Murphy does not have the right to assign you to this case any more than the Grand Pumpkin has the right to assign me here to pass out pumpkins today.
Well, I assume that pumpkin document was some effort at humor, but,
No, sir, it was not.
well,
It was an introduction to show you that mine is not that. Tell me in which manner your document is any more valid than my document.
Mr. Birnbaum,
Judge, have you ever looked at section 74.056 under which that assignment is made? It does not allow Mary Murphy to make that assignment. Would you please look at the law? Until such time, these are just pieces of paper. Voice level 6.
Mr. Birnbaum,
Mr. Banner,
if you would like,
if you would like to.
look, I'm not going to interrupt you. I want you to say what you need to say. You're not
Okay.
going to interrupt me.
Thank you.
Are you ready to present your motion?
No, I'm ready to present what I'm fixing to say.
Sir?
You asked me if I was ready to present what I was fixing to say.
Oh, well, go right ahead. Say whatever you need to say.
Okay. I have presented this already in a document. It's already on file, but at my age 76, my memory is not real good, so I'm using this to revive my memory. It says, oral pleading and writing. The hearing scarificacious to revive, order on motion for sanctions, this hearing before Birnbaum on today's date. My name is Udo Birnbaum, and I herewith call on my right. Now remember, you asked me to hear this, I'm not before you. My name is Udo Birnbaum, and I herewith call on my right to be heard. This will not take long. Please do not interrupt my thoughts. I am 70 years old. 78. I may not have said that right. Your Honor already knows that I am not a lawyer, and that you yourself were the trial judge upon this cause way back sometime in 2002. A quick scan of your findings supporting this order on motion for sanctions should of course immediately refresh your memory even after 12 years. And again, I am not a lawyer, but I suppose that an order can somehow go dormant and can indeed be revived, somehow like a judgment, by the magic of scarificacious, I suppose. In any case, I have Googled on scarificacious and will briefly address each essential element required for revival, as I understand scarificacious. Again, I am not a lawyer. Pause. So as a non-lawyer, pause, and after this short initial presentation, instruct me as to the elements that I may not have addressed in other rights and remedies that are available to me. At issue today regarding scarificacious to revive, whether today there indeed exists an enforceable judgment or judgments, whether such indeed have not been paid off, set aside, pause, or whatever, whether the party wanting to revive, pause, to do execution, I suppose, pause, does indeed have standing to do execution, and by implication, pause, today have standing regarding this procedure to revive. And here's the key thing, and implied in this whole matter is, of course, whether these documents are in fact lawful. 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 Or just void, 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 pieces of paper, inconsistent with due process, inconsistent with due process. Repeat, inconsistent with due process. Also material is whether your very own assignment for today's proceeding is valid and lawful. Or likewise, just another piece of paper. And even if reviving an order is legit. And then there is, of course, another issue of the remote possibility of the appearance of conflict of interest. You, voice level 5, you yourself ruling on the lawfulness of these documents at issue here today. Close to $1 million with interest because of you having been the very author of these documents. Anyhow, please hold any questions just a little longer, and I will finish shortly. And we can then go into an exchange mode upon these concepts. So to continue my introduction, the first judgment was a jury case, as you remember. But Your Honor did not let the jury decide. You did not even put the elements. You did not even put the elements at issue to the jury. You had a jury sitting there. You didn't. Inconsistent with due process. But we can get into that a little later. The second judgment titled Order on Motion for Sanctions. Pause. The sanctions movement had no standing to bring such motions. Besides, the sanction is unlawful, and not only because you did this without a jury. It was a jury case, Your Honor, and you did this without a jury. But because it's patently unlawful on itself. I'm talking about the sanction you put on me of $62,000. A court, by civil process, cannot unconditionally punish by civil process. Period. U.S. Supreme Court. I put that before you in motions during the trial and all kinds of other stuff. Supreme Court forbids this. It has to be. But you did it anyway. Okay? And here are some words out of that. And relief which the court seeks? Have you ever heard in a civil process a court seeks? The state seeks. That was voice level 3. Okay? Relief which the court seeks to stop Birnbaum and others like him? To stop Birnbaum and others like him, Your Honor? From filing lawsuits? From filing lawsuits? Judge, that is a First Amendment right. Filing a lawsuit is a First Amendment right. You punished me for filing a lawsuit. That is official. That is abuse of official capacity. Abuse of official capacity and official oppression per se. You cannot punish for filing a lawsuit. Period. And the third judgment, likewise titled, Order on Motions for Sanctions. 2 years later, after the first judgment, no more case left in there. And that one is plumb insane. Plumb insane, Your Honor. Judge Ron Chapman, another judge, assigned to do a mere recusal hearing, opposing a $125,000 and $770 sanction. $125,770. This was voice level 9.5. And as he found, as a matter of law, Judge Ron Chapman found as a matter of law a delusional belief held only inside the mind of Birnbaum. Judge, you were there as a witness. Judge, plumb insane. And you were a witness at that hearing, and you did nothing. Voice level 8, nothing to protect me from a judge gone plumb bonkers. So much for the unlawfulness of these pieces of paper. Let me next reflect on the lawfulness of Your Honor being here today. And herewith I present my little piece of paper, you already had it, of assignment to me, Uta Birnbaum, to sit on your perch to pass out pumpkins. Forgive me, Your Honor, but sometimes reductio ad absurdum. Reductio ad absurdum. That's Latin for reduction to absurdity. Is the only means to get the attention. Just as a 2x4 across the head is the only means to get the attention of a stubborn mule. Here we have the original from the presiding pumpkin on the first pumpkin administrative region, assigning me to pass out pumpkins from your perch. You might want to rule my assignment as insane or not relevant or not material. Not so. As we said in the preliminaries, your assignment for today is no less ridiculous than my assignment by the presiding pumpkin. Go look very carefully at your assignment. Texas Government Code 74.056 does not permit Mary Murphy to make such assignment. Let me quote Government Code 74. A presiding judge from time to time shall assign the judges of the administrative region to hold special or regular terms of court in any county of the administrative region there are two, to try cases, and to dispose of accumulated businesses, which implies as requested by the court. I'm going to ask a hypothetical question, which let me not ask that question right now. Just like section 74.56 does not allow the presiding pumpkin to make an assignment to hand out pumpkins. But I have a huge moral difference in my assignment. I am not trying to follow through in 2014 on unlawful punishment as you punished me in 2002. All inconsistent with due process. Your Honor, may I strongly urge you to undo the wrong you did upon me in 2002 and cease and desist from doing another wrong here on me today. So, in closing, let me add one more thing. And you can answer that. It allows, 74.056 allows the assignment to try cases, and for accumulated business, I'm going to ask you, after I'm through, which one you assigned for, to try cases or accumulated business. So, in closing, if thou wouldst kindly descend off thine throne, so may I peaceably hand out my pumpkins. Provided with this pleading for your careful scrutiny regarding conformance with section 70.046 are copies of thy and my assignments, both for October 30, as well as one assigning to dispose of accumulated business as requested by the court. I have these documents, and with this I close. And I'm not before you until you show me your assignment as to how it conforms to section 74.056. Your Honor, you're next. It is now 10:15. Judge, I've said my thing. If thou would get off thy perch and postpone this to some other time and get somebody legal assigned in here. I'm not before you.
Thank you very much, Mr. Birnbaum. If you choose not to present your motion, then the motion is denied. Mr. Westfield, you've got a motion before the court. Instant, Mr. Birnbaum, are you now able to hear me okay?
Can you say a little louder?
If you are not, you're physically here today, and if you choose not to present your motion,
Yeah, just a moment. Okay, just a moment. I need to run to the bathroom.